court always has inherent jurisdiction to ensure that the orders that it issues are complied with. As such, the preliminary objection, which does not question the veracity or the legality of those orders, is neither here nor there. And given that Dr. Macharia is already here, this court ought to proceed with an inquiry on the issue of compliance with existing orders.
Can I reply to the word? As I was saying,
what the position is that since we are challenging the jurisdiction of the court, it's proper that we are heard first, without dismissing it, looking at the merits of that application.
looking at the merits of
The merits of the notice of preliminary objection needs to be looked at in detail without dismissing it haphazardly, so as for the court to appreciate the issues raised therein before we go ahead and prosecute. The issue about what my learned friend has alluded to about orders being respected. There is a supporting affidavit that has been filed alongside the notice of preliminary objection, and it is filed before the court.
it says contrary to that statement by counsel. Does it state any contrary opinion?
No, I'm just stating the position.
Respected?
Yes, the position is that
Yes.
the court issued orders for him to appear today, and even though he does not agree that the court does not have jurisdiction to issue notice to show cause, he still appeared anyway and swore an affidavit showing cause, therefore going against the position that he has no reverence to the court. He does have reverence to this court. And that is why we are saying, my Lord, even before we go into the details of the sentence or any other response that might come later, we ask that the preliminary objection be canvassed with first. Because they are
Appeal.
Yes.
Appeal should be straightforward.
Yes, it is.
Can you argue it now? It should be straightforward.
Yes. Yes, it is.
You don't have to say much.
Yes, please.
You argue it now. That's all you're asking.
Yes.
Yes.
Well,
Boy, continue.
Yes. My Lord, Mr. Mbogori has alluded to an application dated 25th of 2025, 25th September of 2025, saying that it's an application that brought forth the orders that were issued by the court.
Forget about those.
Yes.
I need your view.
I am agreeing with that.
Then we will come back to that.
Yes. Because our view is based on jurisdiction, and our position is that when orders are issued by the court to the contender, it must comply with procedural requirements. Those procedural requirements include that
Naam, mtazamaji, kama unavyoona kidogo tumepata hitilafu tu ya sauti, lakini ni hali ambao wahandisi wetu wanajaribu kuirekebisha. Kama ulivyoona hapo picha za mmiliki wa kampuni ya Raw Media Services Daktari SK Macharia pamoja na baadhi ya maafisa wa kampuni ya Directline wakiweza kusikiza kesi ambayo iko mahakamani kuhusiana na usimamizi wa kampuni hiyo ya bima ya magari ya uchukuzi wa umma. Naarifiwa kwamba sauti sasa iko laini. Tusiweze kusikiliza.
Said that failure to comply with procedural requirements invalidate contempt proceedings. There is absolutely no evidence that my client was served with the orders, and the court in that decision further went ahead to state that mere knowledge of the orders is insufficient for contempt. That proper service and penal notice are mandatory. And in fact, in that case, my lord, the case is, yes. Pardon?
When was that case decided?
It was in 1994, my lord.
1994?
Yes, yes. Yes, 1994. Yes. My lord, had my client been given the orders, he would have had the opportunity to respond as a prerequisite to his right for fair hearing. Contempt proceeding must not circumvent fair hearing, so much that service need to be effected properly and procedurally. My Lord, Supreme Court decision in Githaga and 5 others versus Kiru Tea Factory and Company Limited. That was 2023, my Lord. The court was confronted with the fact that it had to decide a decision by the Court of Appeal which convicted a contemner for contempt without considering their pleadings or affording them a fair hearing. And the court said that the Court of Appeal occasion, or the action of the Court of Appeal in doing so, occasion a miscarriage of justice and a breach of right to fair hearing. And it was found that the conviction of the contemners in that decision was found improper. The Court of Appeal, in fact, erred. The reason why we are coming before you, my Lord, is because the Supreme Court has said that these proceedings, contempt proceedings, are quasi-criminal, as you will be aware, and require strict adherence to procedural fairness and due process. In fact, the court said, including clear notice, and used the word meaningful opportunity to be heard. Meaningful opportunity to be heard. Now, coming back to this case as I conclude, my Lord, the alleged contempt proceedings was done outside court and verbally.
What?
It was done outside court.
The what?
The contempt, the alleged contempt. The alleged contempt.
What is the alleged contempt? You are new in this case, eh?
Yes, I am, my Lord, but I've gone through the file.
Let us bring you
Up to speed. Yes, my Lord.
Because I know there are 2 here.
Yes, my Lord.
There is one of depositing the title in the registrar of the courts.
Yes.
That is one of them. The second one is removing the gas power station in the premises of the training council. Those are the 2 things we are dealing with.
Yes, my Lord.
So talk within that context.
Okay. Very well. My Lord, when I was given instructions, assuming the points that I've already raised before the court, even if that are to be placed as a pedestal for consideration, it still does not negate the fact that the alleged contemner before you today was not served with a notice.
Yeah, I'm recorded.
Yes, and as such,
I was just telling you
yes,
the context, so that you
and I appreciate,
the context.
I appreciate my Lord's guidance.
The last week.
Yes, yes,
Now continue.
yes. So I will recheck the last statement then. Yes, in light of that guidance, and I like to state that, my Lord, there was no application. We still insist that there is no formal application. And my Lord, too, the reason why we were challenging the jurisdiction of the court so that we were not just filing the PO is because in those the alleged contempt, the alleged contempt which my Lord has alluded to, were not filed by any party formally, so as my Lord would issue orders and requiring my client to appear to show cause. So we need then service to be proved. So as we do not find. Yes. Yes. Personal service is important for any contempt application. And that is why, my Lord, in the case of Joho versus Doshi and 4 others, the Court of Appeal, it was held in 2024, the Court of Appeal insisted on service personally served on the contemner. Personal service. It must not be served to any assistant or any other person. It has to be personal to the person cited for contempt. That will be all, my Lord. I will ask my learned friend Mr. Orenge if he has anything to add so that Mbogori can respond. Yes.
Thank you. Your Lordship, I do associate myself with the submissions for Mr. Sang for the first defendant. And do submit that the order requiring the first defendant to appear in court to show cause was issued without a formal application being made in that aspect. The court issued that order suo motu before the first defendant was even accorded an opportunity to be heard before issuance of that order, which in the circumstances the court acted without jurisdiction because there was no application upon which to hinge the notice to show cause. As alluded to by Mr. Sang, contempt proceedings are in the nature of a criminal trial, and therefore the rights and procedure, rights of the purported contemner and the procedure to initiate contempt proceedings leading to a notice to show cause must at all times be served and be in the knowledge of the contemner. In absence of that, then the order for notice to show cause was issued without jurisdiction. And before issuance of that order, the first defendant, contemner, was not given a chance to be heard before the order was issued. In the circumstances, my lord, we have to observe the constitutional protections of a right to be heard and not to be condemned and heard. Justice must be served like a sword. It has two sharp edges. Cannot slice by one and leave the other one. So I support Mr. Sang's preliminary objection and urge you to uphold it.
Yes, my lord. In opposition to what my learned colleagues have said, I would first of all point out, my lord, that the nature of a preliminary objection ordinarily requires the same to be argued without requiring the production of evidence, as per the case of Mukisa Biscuits. In this matter, however, the applicants have referred to multiple proceedings and applications which would need to be produced, and their orders and the supporting affidavits thereof interrogated to know what was and was not served upon the first defendant. In any event, my lord, even if the preliminary objection had been regular, it would still be incorrect to state that the first defendant was not aware of the contempt proceedings or was not served with a penal notice with respect to the orders that have emanated in the notice to show cause. With respect to this Honorable Court's orders requiring the first defendant to come to court, in which orders they state were issued summoto, a preliminary objection cannot be filed in respect of those orders because they have already been complied with. Dr. Macharia is already here. We cannot comply and thereafter raise objection. With respect to the applications which resulted in the orders for which the first defendant is being cited for contempt, the respective orders were served on the first defendant, and in particular, my lord, the relevant orders are those orders of Justice Mabea, issued on 4th of October 2024, which injuncted the first defendant and his agents from physically visiting the premises of the plaintiff. My lord, a penal notice was served on the first defendant on 7th of January 2025, together with the orders of Justice Mabea, which orders were annexed to the plaintiff's application of 9th of May 2025. My Lord, it is pursuant to that application that your orders of 2nd December 2025 were issued, requiring the first defendant to deposit the titles of the plaintiff in court. As I have previously submitted, my Lord, the said orders, together with the orders requiring the removal of the security guards from the plaintiff's offices, have not been appealed, set aside, or stayed. And they remain live and uncomplied with. My Lord, under the provisions of Order 40, Rule 3 of the Civil Procedure Rules, the court is empowered. Order 40, Rule 3. The court has inherent jurisdiction to enforce compliance with any interim orders that have been issued. And the said orders having been issued, and the first defendant having complied with the summons issued to him by this honorable court, there is no reason why he should not give evidence or testimony, being personally present, as to why he has not or should not comply with this court's orders.
I have learned. Yes, just mentioning what my learned friends has alluded to. First of all, I've heard him say that the orders were served upon the first defendant. They have not submitted evidence as to the service, because we are alleging that my client heard of the proceedings of today and responded. Even previous service, none at all is present. But upon hearing, my Lord, my client has reference to this court and has showed up nonetheless. Yes, so much that, yes, to appreciate that much as we are advocating for Puritans in procedure, which the superior courts have guided, we have still stated that we have no problem appearing. So much that, my Lord, what you will be confronted with,
You have no problem?
we have no problem whatsoever in terms of showing cause, as you have cited. That is why my client has sworn an affidavit, showing cause as directed by the court, even knowing fully well that procedures were floated from the beginning. No service of orders. Yes, my Lord.
very reasonable court.
I am, yes, my lord. Thank you.
Why don't you go that way now?
Pardon?
Instead of arguing this, I think you argue all of this. And the requirement, we go towards that direction. We can agree on a date when they can come and explain, or you find other directions. And then we move on. Today we don't do anything.
Yes, my lord.
Here he has complied and we appreciate that and we're not going to suffer anyway.
But my lord, can we please also address, I appreciate my lord's wisdom and I will take it. The problem is that when we raise issues of jurisdiction, we would like your lord to look at what we are raising carefully. Give us a decision on the same. I know we are not wasting judicial economy in any way.
Don't worry.
Yes.
I'm here. I like these things.
Yes, my lord.
Court is an experience. Don't worry. Really wanted to go that. It's still okay. But I would just say to be pragmatic
Yes.
so that we don't say anything which is prejudicial to anybody at this stage.
Yes.
We move on pragmatically the way you are suggesting. Macharia here, you're not going to suffer any prejudice today. We don't ask you to play today, to go to the court, you take another time when you can come. Very simple. And then, no, it's not the right way. Get the money.
Unless he's assisting the court.
No,
Yes.
let me finish with you.
Yes.
We are not fighting there, okay?
We are not.
Yeah, we are
Yes,
trying
yes,
to
my
see
lord.
where fairness lies. No?
Yes. You see, I was. Yes.
So, I was telling you you are very useful to court,
Yes.
and the good you suggested. That.
Yes. Yes.
And I was saying, instead of now spending time on electing this one, we don't know which way to go. We go a problematic way, where now we can set a date when you will come and show court, so that we prepare accordingly. I know you are new, so you need to think. So
I am.
System,
Yes, my lord.
that's what I know.
And I appreciate
Not
that.
that kind. So that's what I'm telling you. Very simple. Because eventually we must address the issue of the orders which are subsisting.
Yes. Yes, my lord. I appreciate the wisdom of the court. However, my lord, with respect, I will still appreciate a ruling from the court on the preliminary objection. It will be so much useful because there are issues.
But what I'm saying,
Because if the court says,
yes.
if I have an issue with jurisdiction,
I will make a ruling.
Yes.
I told you already.
I know, my lord. If I have,
It's already your order.
I know that, my lord.
I
And
suggested taking from what you have submitted yourself, which
Yes.
I found to be quite genius, okay?
yes.
If you insist on that, nobody will prevent you from going that way, okay?
Yes, my lord. Yeah.
So it's for you to tell me.
Yes. So, my lord.
I was picking up from where you stopped.
Yes, my lord. So,
So, maybe she was
yeah, my submissions were that, and I thank you, my lord, very much.
submissions.
Yes, I appreciate the wisdom of the court.
No,
The issue I was raising is my PO is premised on jurisdiction. And I know, of course, that if the court finds, looking at the preliminary objection itself, notice, finds that it did act with jurisdiction, then we will not proceed further. Because jurisdiction is everything. I still appreciate.
I would like you to cut out your space. Right?
Yes.
Cut out your space. You're using it.
I am.
Cut out your space.
Yes.
Of your PO. Because there's no way you can say the court cannot proceed. I have permission to deal with this one. The question of whether
On the issue of
you
notice,
succeed or not,
yes.
you can only succeed if you succeed by saying a notice be issued. Are you getting it?
Yes.
Yes. So cut out your space here.
Yes. We'll
So you know I like being fair to everybody.
yes.
That's why
Okay.
so cut out your space. So it will not give you that foreclosure you're talking about. Even if you succeed. We will only say notice be issued now.
Very well, my lord.
You will not set aside the orders upon which the contempt is based. You are getting it, eh?
Yes, my lord. Sincerely, my lord, I really appreciate. And being an officer of the
Something
court,
that you are responsible. You are a good person.
Thank you, my lord.
Now tell us, what do you want us to do?
My lord, in light of the wisdom that the court has alluded to, and looking at the circumstances which you have appreciated, it will not be, I will be acting amiss if I have altercation with the court. I like you.
No,
I like.
there's no altercation.
Yes, yes.
We are having a conversation.
And I'm glad, my lord.
We are having a conversation.
So, my lord,
I will not record it here.
if you,
What else we are talking? Everybody is here.
Yes.
I will not do it with the camera.
yes, if indeed my client,
Whatever you insist, want me to write it, what I will write.
yes,
What I will
yes. In fact, I was telling Orenge, I was letting Orenge even give a comment so that we don't have divergent views on the same, because he has supported my application through and through. Yes.
What do you think about what we are saying?
Very briefly, my lord.
What do you think? You are not supposed to anything.
Yes, I think I first need to comment on the line Mr. Kemo is taking, in that the nature of this preliminary objection would really help a lot of circumstances if a decision is made to set a precedent. To set a precedent, not just for us, it will open the law and reasoning of the court when challenged with circumstances like this one. And then after that, whichever way it goes, then the court to recall the first defendant, I'm sure is able and willing to come and show cause. I think that would be fair to both parties.
No problem, I'll write a ruling.
Thank you.
So can you conclude one line? I don't know what to do.
Yes, my lord. Yeah, so, I mean, we had already gone so far to the extent that if the issue is jurisdiction, of course, my lord will canvass that. But I appreciate what my senior, Mr. Orenge, has said, that it will assist in precedent and also moving forward in this matter. So having it on record, my lord, I will still insist that a ruling way will be the way to go.
So there's nothing substantive there. That's what we have agreed.
Yes, so much that now you will give us directions on how to proceed in terms of the PO, whether you want us to prosecute by way of written submissions or you will just give us... Yes, these are the submissions. Yes. So, yes. So a ruling date will suffice? Yes, my lord. Thank you very much.
My lord, before you give your final directions, I wonder whether you'd be willing to give us 5 or 6 minutes. I'll speak with my colleagues on the side. Just, I'm requesting...
What about a ruling date? They're saying they want a ruling date.
Yes, and
we are agreed. We are going to have a ruling date.
the interest...
Unless you have some...
Maybe, my lord, to give a proper guidance, before you listen and finalize what Mr. Mbogori is asking for, we have other counsels for other parties. Could you kindly find out from them, because they are already on record?
I will come to them.
Yes.
Don't worry. I want to keep the whole part.
Thank you, my lord.
Yes,
So, Mbogori, I'm talking about a ruling date.
Yes.
That's not negotiable. We are going to give a date for
We're going to give a ruling.
which will be 2 weeks from now.
My lord, what I was going to say is that
Unless it's something else.
it is, you see, the issue before the parties and before the court and before everyone is really an issue of contempt and compliance with court orders. Now that my colleagues and their representation here, the first defendant is here, if it is possible to agree on a compromise that resolves all of this.
Look, I think Kemoi will go and converse with the plan. That's why I was raising all these issues so that they can go and sit down and talk. Okay? And Kemoi appreciates
Yes.
the seriousness of contempt of court.
Yes.
So then it's good that we are willing, but let Kemoi have an opportunity with this plan.
Yes.
But if they are willing to reach a compromise, which is okay and does not violate the law, then they will come and they will record it.
Very well. Then we can take a
ruling.
ruling.
Even from the court, you saw the way you are having a conversation about
Yes.
action in the right to achieve. No, that one is still on the table. Don't worry about that.
Very well, my lord. We can take a ruling.
So we'll take a ruling date 2 weeks from now. That will be not next week. The other week.
No problem.
The other week. 15th.
The other it is on 12th November.
Yeah, 12th of February. But before I do that, and the council who wants to say anything about the PO, not about the case. The PO. You have anything?
Let's just briefly,
About the PO?
Yes, the PO.
That is Kivara.
Yes, for the court defendant.
Yes.
Lord, having had submissions by council on both sides and having had the submission you have proposed,
Yes.
I believe it would be fair if you give us a ruling so that we may appreciate the court's reasoning on the way forward that we provide.
Thank you. We have agreed on that. Eh?
Yeah.
We are trying to do say this is to the
My lord, I will file them.
Yeah, because
Yes, I will serve.
File them by tomorrow.
I'll file them by tomorrow or this afternoon. By tomorrow, I will have send all the decisions. Yes, I will. Thank you.
Your Lordship, on the seventh defendant's part, we will be sitting out of this application because it doesn't confirm us. Yeah.
I've cited 3 authorities, my lord.
Make it today.
Today, yes, my lord.
Sure you file it.
Yes, my lord. I will file it today.
But as I always say about this case, because I'm aware of what is happening around this case, there are those primary issues which have to be decided. And then above all these other events, that's the shareholding and equity. These are the 2 major issues. Quite foundation and also operation in terms of how the society is formed. So, I do not understand why you are not pursuing the solution of this case. Because if you did, then you will not be here talking about this. If that is settled, it will have what I normally call distribution of consequences. No other matters. Is that not the position?
Maybe your Lord yes, but you will note from the court records in various matters touching on shareholding and directorship that it's the plaintiff who keeps on filing application after application. If those applications can be done away with, then it will open an avenue for addressing the substance of the case. But the moment parties keep on pumping applications, we'll never move.
And it is 2 ways of looking at those things. Okay?
Yes.
First, the conduct of the property.
Yes.
And then filing of application.
Yes.
They may be within the council. But if parties can agree, we are going to maintain a conduct which is consistent with the rule of law and fairness. And then we do not file applications, we go straight to the main issue.
Yes, I'll urge your Lordship that once you give this ruling and we deal with the issue of contempt one way or the other, I think an order should be made for non-filing of interlocutory applications. We deal with the substance.
If I were to stop you to filing, you will go to the Court of Appeal very quickly. So let us not go that way. But we can agree
Yes.
as our by way of directions. We
Yes.
say no application to be filed, okay? And those which have been filed are compromised. And the consideration is that we do the main hearing. You see, there is a consideration.
Yes.
So that kind of order will make a challenge. Deal with this at
And in fact, it will. The fact is, through their council, will sign the written consent by you. They sign, so that there is no avenue of saying I didn't participate.
I wish if all these matters were before me, that is what we have done. And now this Directline issue would have gone long time ago. So the parties, they know their position. If you are not a shareholder, we say you are not. If you are a shareholder, we say you are. And then now from that we are able now to move without the...
My Lord, after we are done with these current proceedings, I think we'll find a way out.
Please.
Yes.
Find a way out.
Thank you.
You are a senior Muslim, isn't it?
Yes.
So I said find the way out. A pragmatic approach. Pragmatic approach. That is the one. Even when you look at our constitution, that is what it is. Not really strictness or procedural technicality, so that you get fairness, okay?
Speedy hearing.
Speedy hearing, and you also get a decision which takes into account the various different nuances of the parties. Very simple.
Yes,
you already understand what I'm talking about. And you will sit down, all of you, and then have a one. Then you will see this thing will be gone immediately.
I'll initiate that approach.
Please initiate. Because why I'm doing it is every day before I start proceeding, I pass that message on how to talk. Because I'm also a member of National Security Committee or Committee Justice System. So it is my obligation to encourage parties to take control of their own processes and make decisions which are theirs and they can appreciate. I can say give and take. When we have a dispute with you, you ask me to pay you $100. I can offer to pay you $50 and you accept and you say it is in full settlement.
That is why we have
but when you come here in court, will I be able to do that?
No.
I would say no, pay high. You see the difference between the two?
Yes.
Yes, that's it, for example.
To get to the 100 will take 5 years.
Yeah,
to get my 50 will take about 6 months to get
to the 100.
Yes.
But here I'm offering you it is indeed your part to accept it, considering all these factors. Take that and you will never regret.
I will initiate.
Even if there was any revolution which went against the grain of the truth, when you enter into those settlements, there is no decision you cannot accept. Even if it is made by the institution and the parties are doing it out, that is what they do. This is the beauty of practical.
Yeah.
And I would encourage you already to do that.
My Lord, I've promised you that I'm going to initiate that part.
Please do.
Yes.
And then tell the parties it is without prejudice. Whatever
Definitely.
they say there will not come to
Yes.
be used against you.
It will only come here once we have agreed.
Once you agree.
Yes.
Tell parties that so that they don't use this case. So thank you already. And everybody else. I think now we can go and enjoy ourselves.
Good day.
We are not enemies.
Yes, my Lord. And thank you so much, my Lord. I appreciate you, my Lord. Thank you, my Lord.
Maybe they don't know you are practicing. He was practicing in Eldoret, if I'm not wrong.
Thank you, my Lord.
Yeah. Yeah, I wish you all the best.
Yes.
May God bless you.
Thank you.
Thank you.
Uniite chai basi. Nasikia Jaira amesema uniite chai. Uniite chai.
Naam. Chukua namba ya
mtazamaji, matukio ya moja kwa moja kutoka mahakama kuhusiana na kesi ya mzozo wa udhibiti wa kampuni ya Directline Assurance Company, kampuni ambayo hutoa bima ya magari ya uchukuzi wa umma. Ni mzozo ambao umemhusisha mmiliki wa kampuni ya Royal Media Services na kampuni ya Royal Credit, Daktari SK Macharia, pamoja na wale wanaodai kumiliki kampuni hiyo ya Directline. Kesi bila shaka jaji akiwa ametoa uamuzi kwamba atatoa mwelekeo baada ya muda mfupi kuhusiana na kesi hiyo.